morning, Your Honors. May it please the Court, my name is Jack White. I am representing the mother in this proceeding. We have appealed an order entered by the court in Pasco County that resulted from a combination of a mediation and a pretrial conference. This order purports also to make a finding of dependency as to the mother. Prior to...
Can I ask you, Mr. White?
Yes.
There's nothing in the record to suggest that the current placement of the children has changed?
The children... There's nothing in the record, Your Honor, but
It was a relative placement.
At present, the parents, the children have been reunified with the parents.
Okay. And there's, at the hearing, I'm having a little trouble. I'm trying to figure out how your client would have had any understanding that there would have been any result other than the finding of dependency and what was then, I guess, the relative placement.
And I do want to, I feel that if you just only go by the transcript, you would get that impression. But you have to read the mediated agreement and go through it in detail and to understand what happened, because we have essentially what I view as a contract between the department and the mother. That contract was the mediated settlement agreement, and specifically said that it would be entered as a consent order. And that contract, Your Honor, does not make a provision for that adjudication. It's left blank. I don't know for sure who was responsible for leaving that blank, but it is left blank. There is no agreement in the mediated agreement for an adjudication of dependency as to the mother. And the mother, prior to that time, had entered a denial on the record. So at the time they reached that agreement, the mother had already denied the petition for dependency, and that was the state of the affairs at the time.
But I then have a hearing before the trial court.
Yes, Your Honor.
Which seems pretty clear that this is heading towards a dependency finding, and there doesn't seem to be any objection at that hearing as to what ultimately happened.
Well, there is an appeal, Your Honor,
It's not clear to me that the mother had an understanding that it was going to be anything other than a dependency finding.
And at the same time, Your Honor,
Pursuant to this agreement,
there is no understanding by the mother in the colloquy or the discussion by the court that they are going to be doing something different than what's in the mediated agreement. And that's what's critical, Your Honor, because Judge Wallace's opinion in BG versus the department, the court's very careful to cite the Rule 8.325C. The court shall determine that any admission or consent to a finding of dependency is made voluntarily and with a full understanding of the nature of the allegations and the possible consequences of such admission or consent, and that the parent has been advised of the right to be represented by counsel. The court shall incorporate these findings into its order in addition to findings of facts specifying the act or acts causing dependency, by whom committed, and the facts upon which the findings are based. Now, when you have a mediated settlement agreement that does not provide for a finding of dependency, under this rule, you have to have a discussion about, ma'am, do you understand that what we are about to do is different from what you have agreed to in writing? And, Your Honor, the mediated settlement agreement says it will be entered as a consent order. And then you have this word consent being used at the hearing in a way that's completely confusing. If you look at the transcript, here's the judge expressly stating, without reading the mediated settlement agreement, it looks like this is what the parties want to do. So if you can imagine in the context of civil litigation, if you have a court ruling on a contract without reading it and saying, well, I think this is what the parties intended, that would never fly. It just couldn't possibly operate that way. when you have an agreement that's got something directly contrary in it, which is no agreement to a dependency and a denial of dependency on the record. You can't jump over the agreement and rewrite it without making the findings. That's required by Rule 3.25.
If there's no finding of dependency, is a court authorized nonetheless to require the mother to do the case plan?
Of course, Your Honor. Of course, that was the whole idea, is for the mother to get over this thing, was agreeing to work a case plan, but it did not include a finding of dependency. She wanted to do anything she wanted to do to get her children back because, frankly, the custodial parent or the grandparent that they put this child with, this is, one of these it's a small world after all cases, Your Honor. We just happen to have represented the custodial grandparent's other in-law in a dependency proceeding, or not, a custody proceeding in Hillsborough County, and this custodial grandparent, and this is in the record in an affidavit, he openly defied and abetted the defiance of a Hillsborough County court judge. And this is what had the mother so concerned and refusing to agree to...
Let me follow up on Judge LaRose's question. What's the authority of the trial court to require the mother to work a case plan absent a finding of dependency?
I think it's like any other civil proceeding. You can agree to do anything you want with the state. I mean, and that's, again, Your Honor, where's the explanation in the colloquy about that? There's no explanation. You understand that in order to work a case plan, you have to agree to dependency. Why isn't the form filled out then? This just goes around in a big circle. You've got a written...
This lady was unrepresented either. She had counsel with her at the hearing.
She had a perfect storm of mistakes, Your Honor. She had her counsel that was at the mediation become a circuit judge and then not be there. She had a judge that did not read the mediated settlement agreement, and then she had a counsel with her who only had been practicing 1 year. But this case still comes down to you have to have more than just and I wanted to point out one thing, one particular line.
Before you go there, how many pages was this mediated agreement?
I think it's 7.
7. And how does it differ from the stipulation of the parties?
It is the stipulation of the parties.
The
It is a written stipulation.
All right, the stipulation of parties in paragraph 3 says that the parties agree that the factual basis for the finding of dependency is domestic violence. Is that the correct document?
There was already a finding of domestic violence as to the father.
I understand that, but we're talking about dependency, and then you say with consent, it seems to suggest with the case plan, implicitly at least, that there's going to be a finding of dependency in order to move this along.
And there already was a finding. The mother thought that finding of dependency was the father's finding, and she's working the case plan so they can be reunified and get this thing worked out. And as I said, I want to just point out a line.
Can I ask you something, Mr. White? If we agree with your position and we reverse, where are we?
We are simply reversing the adjudication of dependency as to the mother. The mother has done what she agreed to do.
I don't want to go beyond what's in the record, but let's see if we can project forward. If we agree with you in reverse, and if I assume that she has completed the case plan that the trial court ordered her to do we have a question as to whether this case is still live?
There's still a finding of dependency as to the mother, and that follows you for the rest of your life.
Your position would be that has some collateral
Yes.
consequences down the
It
line.
had collateral consequences during the pendency of this appeal, Your Honor. When the mother got some disturbing news about the custodial grandparent, she tried to go to another house with Sandra Robertson, who is also approved to be a custodian, and that happened to be in Missouri, and that upset Judge Webb quite a bit, such that even though no one asked for it, he ordered the children pickup order and a warrant out. So yes, when you have a finding of dependency against you, there are collateral consequences you can't avoid.
Your situation there is a direct result of a finding of dependency and the court's decision as to where the current placement has to be. that's a little different from my concern as to if we reverse and she has done everything she's supposed to do, I'm not sure how the collateral consequences follow forward if the children are going to be reunited with the parents.
I think it's a simple matter of wanting to have your name clear, Your Honor. I don't think anybody can understate the importance of having your name clear. In this day and age where something that even that you thought might be private can be circulated to millions of people, a finding of dependency, should it ever escape, it could dog her for the rest of her life. And I wanted to, I'm still trying to read this one line, but this is, says the court, all right, ma'am, this is going to be without admitting or denying any of the allegations, and I'm clear with you, I'll accept it on that basis. Well, it meaning the mediation agreement or a plea to the consent of dependency. It's simply not clear, and the court does not go through the agreement and see that there's blanks in there and tell the mother, hey, we're filling in the blanks right now, lady. Just so you know, so you understand what you're doing. We're filling in these blanks. It says that I didn't see agreement here, even though the mediator's report says it's a full agreement, but we're filling in that blank right now, so you understand that. That's what had to take place under Rule 8.325C. You can't have a mediation agreement that doesn't provide for something, go into court and then do something different without telling the person that you're going to do something different. And I would also like to reserve 5 minutes for rebuttal if necessary, is the findings of fact that are required by this rule are not present in either the written order or at the hearing. There's just a reference to, he says, failure to protect. That's all it is. And it's said, so, and you can tell that the judge is not even speaking in complete sentences this court. They're trying, you go in there, it's a room 2/3 this size, it's packed with people, and they're trying to get them through there. And it's an unfortunate situation, but we can't run over people's rights and put a finding of dependency on them simply because we got in a hurry one day and we didn't have time to read the agreement and tell the person that what we're doing is going to be different from the agreement. And if there's a finding of dependency, we have to have the facts that support that finding. And they aren't in the written order, and they aren't made at the hearing. There's just one line, failure to protect. How does the mother govern her behavior?
There is a record that sort of traces the instances of abuse and failure to protect, is there not?
There is. The only allegations are of a single incident where the mother was attacked by the father. And
I thought there was something in the record about, the children testifying about multiple instances of domestic abuse.
Not at this hearing, Your Honor. There was nothing proffered, and there's nothing in the petition about multiple instances of abuse and the children witnesses. In fact, they stretched this as far as you could possibly stretch it. They said that one child saw it, and the other child saw the other child react to seeing it. And the other child was in the bedroom. That's how far they stretched this, because, Your Honor, if you think about it, there's apparently some motivation on the part of the department to get a dependency finding against both parents to get complete control. Because if you only have one, a finding of dependency as one, what have you got? You're showing, one card in a game of 21, and the dealer's got 20, and you've got one card, and you can't get the other card. You're never going to win that game. You're never going to have control of that game unless you have a finding of dependency. And unfortunately, I think that the state was trying to get there, and they got, like I say, a perfect storm of events. But again, I want to stress, Your Honor, that she did not consent, and that is why we are here and appealing this. Is she denied it. There was no agreement for it, and when you go through it with the understanding of the totality of the circumstances, you cannot conclude from the language of this hearing that she was fully informed and the court made the necessary findings.
Good morning. May it please the court. My name is Leslie Lane. I represent the Department of Children and Families in this matter. just, the department like to say, dependency is not a game. It's a very serious case involving families, children, the parents. We're not here to play gotcha. We're not here to punish the parents. We're here to help. On the one question, if this case is reversed, what's going to happen? Well, generally, if it was reversed, the department would get a chance to prove its case or prove the dependency allegations against the mother. However, we're so far past
Well,
that.
yeah, I mean, as a practical matter, you start off with this agreement, and it really, it's not clear to me where the breakdown was, because it appears as though there was going to be a consent to something.
Yes,
Maybe
sir.
going only so far as to do the case plan. And then at some time, this thing morphs into a dependency finding.
Yes, sir.
So maybe you can help me out on
I
where
don't-
this gap,
I
how
think
do we fill this gap?
I think it occurred after the hearing and later down. I think the mediation agreements, I don't think it's contrary to what happened to, at the hearing. The hearing's very clear. The mother, the department filed a petition against, alleging allegations against both, regarding both parents. Father consented, children adjudicated. We still had the petition out there with the allegations against the mother. We still needed, she wasn't a non-offending parent. There's nowhere where this department says we're not going to make her enter a plea to the petition, which we do in some cases. We did go to the court. Actually, we set a trial or adjudicatory hearing for October 20th, so that was still pending. The court ordered the parties to mediation. Now, maybe the mediation agreement should have said the parties agree that the order of adjudication will be supplementally adjudicated with this finding. I think that's kind of implicit in this mediation agreement. It doesn't state that exactly, but it does have a finding that the parties agree that a finding of dependency is domestic violence. We didn't check the box, or they didn't check the box that the children will be adjudicated dependent because they were already adjudicated dependent. And I think when you look at what happened a few days before the pretrial hearing at mediation, and then all the parties are at court, in a very, actually, it was not a rushed hearing. The court took time with this mother and her attorney and the parties. The court went through a very thorough, or had the state go through a very thorough quality. There's no gamemanship, there's no hiding. We weren't playing tricks. The court said, or the mother was asked, did you have adequate time to review the state's petition for dependency? Yes. Is it your intent to enter a consent to the petition without admitting or without denying the allegations? Yes. Are you entering your consent freely and voluntarily? Yes. And then,
But why shouldn't I take Mr. White's position to the extent he analogizes to civil litigation? You've got these allegations of dependency. The judge sends you to mediation. The department and the mother agree. We're not going to admit any liability, but I'll tell you what, to get this resolved, I'll enter into a case plan. End of discussion. And then we get to the courtroom, and I don't know what's happening with the mother's lawyer, but I don't see DCF standing up and saying, no, Judge, that's not quite what the agreement is.
because that, I think the parties agreed that was the agreement, and by statute, we have to, for lack of better words, deal with the allegations against the mother. Either the department has to tell the court, we're not proceeding against the mother, and there is a provision that the court can order the parent to complete a case plan without finding
But
a
that's what you
dependency.
did, isn't it? What the mediated settlement agreement says, DCF has an interest in making sure these children are protected. So we're going to make sure that the mother agrees that she's going to do an adequate case plan. And at the same time, she doesn't have to admit to the allegations in the dependency
Well,
petition.
I think we would also, at that same time, have to look at giving the children back to the mother, because why wouldn't we have a fine? And actually, let me just back up. The mediated agreement actually does have a paragraph in there that it says there will be a finding of dependency of domestic violence. So that is as to the mother. And the mother signed the agreement. So I think there was contemplated that there is going to be a finding, not just that the mother will get a court-ordered case plan, that there is a finding that they said that domestic violence is the reason to finding a dependency. And that's something that the court needs to find, whether the mother contributed to the dependency of the children. So I don't think it's opposite. I mean, I don't think they're contrary to each other, because I think the mediated agreement does say, because why else would we include that finding a dependency of domestic violence in a mediated agreement if we weren't contemplating? And why wouldn't we put in a mediated agreement that the department is not proceeding at trial against the mother? And after the mediated agreement, the hearing is very clear. The mother was asked over and over, and her attorney, do you have any questions? Is there any other questions before the court accepts your consent? Then the court later asked again about placement and visitation issues. Was there anything else to address? Mom was asked, she could have the chance to speak. It was a very, from reading the transcript, this wasn't a quick hearing, a rushed hearing, or like the judge was being overbearing. He was there to make sure, and he even said, we just want to make sure you have everything. I'm paraphrasing. He wanted to make sure she understood that the case plan tasks were to address the issues that brought the children into care. So the department, as far as finding that this order should be reversed, after the mediated agreement being given to the court and a hearing at the pretrial where the court has to decide, are we going to trial in just a week or so, or do we have an agreement that between the state and the mother, what else was the court to do? There was no abuse of discretion here. The court had a parent before it clearly consenting. It's not like the BG case. The BG case is not applicable. The BG case had a mediated agreement with the father. This was prior to disposition. But in that case, the court didn't undergo the plea colloquy to determine the father's understanding, whether this consent was knowingly and voluntarily entered. At the case, our present case, the language was used, have you read the petition for dependency? Are you going to consent to the petition for dependency? It didn't say consent only to work a case plan. And I don't think the transcript's very legible. And you can read it, it's very clear. And the mother, there's no objections throughout any of the hearing by the mother. In statutory, we either have to dismiss our case against the mother and find her a non-offending parent or a non-custodial parent seeking custody, have her enter a consent, or omit. Those are our options under the rules and the statute. So we still had to, deal with the mother's situation. And nowhere in the immediate agreement does it say this department is not going to go forward to prove its allegations.
Well, you just spoke of 3 options. And if those are the only 3 options, I don't understand why you even bothered with mediation and entering into a mediated settlement agreement, because that doesn't sound as falling into any of your 3 options.
Well,
Just to admit?
to omit the allegations in the
deny.
petition. Deny.
Consent to a dependency.
Or at mediation, a lot of times, the department will take a step back and say, well, what's going on here? Can we put the children back in the home with the parent now? If so, then under the statute, there's another option of, we could put the children back with the mother and still have a completed case plan.
But at that hearing, I don't think anyone contemplated that kids were going back to mom that day.
Not the department, not from the guardian. It was actually brought up about, we talked about the placement with the paternal grandparents, the visitation between the mom, and some concerns the department and the guardian had. According to the briefs, the mother says after the fact that she thought she was going to get her kids. This is not in the record. This is in argument. She thought she was getting her kids back that day, and be reunified. But no, nobody contemplated at the pretrial hearing where this was accepted, and the mother consented, that she would get her children back that day. And actually, the court addressed that issue and said, well, you know, Mom, we don't want you to say anything that makes these kids think that they're coming home today. So I agree with the court that we weren't placing the kids back. So I don't think, in looking at it in that light, the mediated agreement and the consent by the mother, it makes it even more what the parties contemplated of doing, of entering a consent to the petition, having the finding of dependency regarding domestic violence, and the court made its own findings in addition to what was in the mediated agreement, and then the mother being court-ordered to complete a case plan. So,
Well, how do you respond to Mr. White's suggestion that the order is inadequate in terms of its findings?
I don't think the order is inadequate. I think should it had a little bit more? Possibly. But the court, on its own, it decided, without any prompting from any of the parties, it said we're going to look at count 2, we're looking at sorry. It was going to supplementally adjudicate the children dependent based upon a specific finding under the petition count 2, abuse and neglect, failure to protect based upon domestic violence, and count 3, prospective abuse and neglect for domestic violence. I think that's clear enough to say what were the issues at hand with this family as far as the mother's actions or problems that the department had with the mother, and why a case plan would be needed, and what case plan text would be needed to alleviate those concerns, domestic violence, failure to protect. Maybe it should have been a little bit more, but I don't think it's not inadequate. And also, the court also included in its order the findings that the mother knowingly, voluntarily, freely entered a consent. She's represented by counsel. I don't think the order is inadequate. I think it's sufficient to base the supplemental adjudication to the order of adjudication. That's a lot of words. But I think it is sufficient because it's clear that, and if you look at the petition for dependency, it did allege domestic violence. The petition for dependency was sufficient. There were paragraphs in there that allege, and now if we had to prove at the adjudicatory hearing, the department alleged the parents have a history of domestic violence. The mother admits they have a history of domestic violence. Additionally, the mother has frequently appeared with bruises that she explains are the results of falling. The child SW stated that her father only hits her mother when he is mad. The child stated the father only hits the mother and this makes her a little scared. The child KW the third stated that it scares him when his parents fight. The child stated the parents yell and hit, but the mother does not hit the father. So this isn't a one-time incident. I think the petition for dependency was sufficient to allege enough facts to support the finding. The court order is sufficient. I don't think it's inadequate. The court, there's nothing in the transcript that shows that the court did not make up its own mind regarding the findings it was going to make. And there was no objection by the mother or her attorney at that hearing. The court said, I'm going to find this. And then at that point, I think if the mother thought she was getting her children back that day and not entering a consent, I think the mother would be like, well, why are we doing this? Why are you making that finding? And there was no adversarial nature between and a hostility. The mother it appeared to me that she was free to speak and ask questions at that hearing. The department also just wants to touch that regarding some of the case law presented by the appellant. The KS case that was represented in the reply brief, the department would say that that case is not applicable. We're not using the father's consent against the mother. The mother had her own process. The father was dealt with early in the proceeding. The adjudication order for the children was completed. The mother had her own process. Due process was present. She was aware the petition for dependency was filed. She was aware there was an adjudicatory hearing scheduled in October. She knew she was ordered to mediation. We're not using the father's consent against the mother. The only thing the department said in the brief, we didn't need to check the box that says the children are adjudicated dependent because we can't do that. They're already adjudicated dependent. We're just making a finding as far as the mother's status. Did she contribute to this dependency? And what was the basis for that? I've already spoke about the BJ case. There was a brief statement of facts upon the finding of dependency made by the court. That has to do with the order being, I believe the order is sufficient. It is brief. But I think in the realm of domestic violence and failure to protect, I think that was sufficient to advise, okay, I'm going to do this case plan test. What domestic violence victims? Okay, are there any more problems engaging? Down the road we can say, well, yeah, is she substantially compliant? Yes. We look back at the order. This was domestic violence. She did the domestic violence. That's good. And then also the department would also address that appellant argues that there's a denial of due process is relying on the JB case out of this court. While I think due process is relevant, I don't think this case law is applicable to this case that dealt with the closure of a case with permanent guardianship and no notice to the parent that the department was going to recommend closing the case that day. And there's reference to, by the appellant, that the department said no findings were needed. I don't think this is accurate. Definitely you have to have findings. Now, they're brief, but I think they're sufficient. So I think the record is clear. There's no trickery here. The language used at the hearing was very clear. Mother can consent. Have you reviewed the petition for dependency? Is it your intent to consent? Also, another issue is that when the court ordered the parties to mediation and set the adjudicatory hearing, in that order, there is a finding in an order that if the mother failed to appear at that adjudicatory hearing, then the order of adjudication would be supplemented to include the mother. I think that also goes to the mother's knowledge that, okay, the state's not, the department's not going to dismiss its case. Nowhere in the record or the mediated agreement says the state's not proceeding with the allegations against the mother. So I think that also goes to the fact that the state was proceeding without, not just letting this mother be a non-offending parent.
Don't you read too much into that? I mean, that's telling her what's going to happen if she doesn't show up.
Right.
DCF and the mother reached some sort of agreement at mediation. So that warning just doesn't seem to be relevant to me.
Well, I think it's relevant because the department didn't say, okay, what was said is, Judge, we're not going to trial on that, at that pretrial hearing, we're not going to trial. The adjudicatory hearing will be canceled. The mother's agreed to consent. And then when you supplement the mediated agreement with what happened at that pretrial hearing, well, okay, the department is not going to trial. Well, we have to do something, and there's no requisite finding saying, okay, well, Mom, you have your kids back today. So it's just a little bit more to show that what would have happened. Like, we have to deal with the allegations against the mother, or the department needs to dismiss his case, the allegations against the mother, and request the finding that she's a non-offending parent or non-custodial parent seeking custody. And maybe at that hearing, if we're not going to keep proceeding against her, well, we have to figure out, do we give the children back to her at that hearing? So we respectfully request that this court affirm the court's order. There's not been an abuse of discretion by the judge. The record clearly shows the mother consented. The requisite findings were made for the consent, the knowing, voluntary, freely entered, and also the finding of, finding of dependency, or the allegations against the mother. The court made findings that were clear. Thank you.
I would like to go back to the mediated settlement agreement again. point out to your honors that it does say domestic violence in it. It says they agree to, that there's a handwritten note underneath it that says they agree to the basis for the finding of dependency is domestic violence. But the mother didn't commit domestic violence, the father did. If their argument has to have any traction, that one line in there gets them to an adjudication of dependency for failure to protect, it doesn't say failure to protect, it says domestic violence. That was the father's actions. And I think that conclusively ends the story about who they were talking about. The only person they could have been talking about in the mediated settlement agreement was the father. Domestic violence by the father. There's no allegation in the petition about domestic violence by the mother. How could that be a basis for a finding of dependency as to the mother? It simply doesn't work. This is a written agreement. It has specific provisions in it. If they wanted to fill in provisions at that hearing, they had to tell the mother that they're going to do it. That's what the BG case requires. It requires knowing consent. And you can go through this transcript over and over again, and you don't get there. You don't get the kind of questions that you need to get past the mediated settlement agreement. And it says it is a full settlement. Who wrote that? That's in the record. I just, unfortunately, the court starts out saying, okay, and state, without actually reading all through it, it looks like the mother would like to change her plea to consent and agree to work a case plan. That's consistent with the mediated settlement agreement. And I still have to say, Your Honor, that the findings as to failure to protect are not there in this order. And that's required by the rule. It doesn't say, just say the line, failure to protect, at the hearing. It says, the court shall incorporate these findings into its order in addition to findings of fact specifying the act or acts causing dependency, by whom committed, and the facts upon which the findings are based. Those are not there. And we believe that this order of dependency does need to be reversed. It is a genie in a bottle that's waiting to get out and wreak havoc with this mother. No one should have that kind of thing hanging over their head for the rest of life. Is this ever going to come up again? Am I ever going to have a brush and someone's going to go somewhere and, that gets hacked, the computer system gets hacked, it gets out? You can't have that happen. Not when you don't have a clear record, not when you have a mediation agreement that says something different. So we ask the court to reverse the finding of dependency. Thank you.